Yes. People versus Kylander, case number 244883. I could have counsel put your appearances on.
Brian's in Columbia. He's on it.
Tell me what you're doing with the idea of Mr. Kylander. I have this set for a plea hearing today. Is that how we're going to go forward? Yes, Your Honor. Your Honor, it's my understanding that Mr. Kylander would be tendering a plea to one count for 10 days. Obstructing. In exchange for that, the other counts would be dismissed. Mr. Ziegler?
Fair statement.
Okay, Mr. Kylander, have you had a chance to discuss this plea agreement with Mr. Seeger?
Yes, sir.
Okay. And is that what we've said here in court today? Is that the plea agreement that you haven't discussed with him?
Yes, Your Honor.
Is that how you want to go forward today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the, that's okay, will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Kylander, are you currently on any kind of probation or parole?
Not right now, no.
You understand that the maximum penalty for attempted resisting and obstructing is 1 year. I just need to answer verbally. Okay. With that maximum penalty in mind, what is your plea to that charge today?
I'm no contest.
Okay. Mr. Seeger or Mr. Ziegler, have you guys discussed the no contest plea?
We have not, Your Honor, although I suspect that there might be a basis for it depending on whether he testifies that he has a memory of the incident or not.
Well, let's try this, Mr. Kylander, or if you would.
Sure.
Mr. Kylander, on the date in question, law enforcement were dispatched to your home, is that correct?
Yes.
And when law enforcement came to your home, they were properly uniformed.
Yes.
They were identified as law enforcement officers.
Yes.
And you knew that they were in fact law enforcement.
Yes.
And this occurred in Kalkaska County, correct?
Yes.
Right. At the time that law enforcement approached you, you were aware that they were investigating a complaint, correct?
Yes.
At which point they asked you to turn around, correct?
Yes.
And
I
you
failed to comply.
All right, and you didn't follow their lawful command, knowing that they were police officers, correct?
Yeah. I really couldn't see him through the glass, but after he mentioned it, that he was with the sheriff's department, I failed to comply.
Okay.
Okay, thank you. So Mr. Kylander, you understand that whether we term this a no contest plea or a guilty plea, that you're going to be giving up certain rights by doing that?
Yes, I understand.
So you have the right to have a trial, you have the right to be tried by a jury, you have the right to be presumed innocent until proven guilty.
Yes.
You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all of those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights today by entering this plea?
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead?
No.
Has anybody promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes.
Okay. I think we already have a factual basis. Mr. Ziegler, would you agree?
I'm satisfied with the factual basis.
Okay. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Kylander, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied based on your testimony that there is a factual basis to support a finding that you are guilty of attempted resisting and obstructing.
Yes.
The court will accept your plea. You're going to meet with Agent Barra before you leave here today.
Okay.
And then we'll set this matter for a sentencing hearing. It's just important that you stay in touch with Mr. Seeger, of course, prior to that hearing date, okay? Mr. Ziegler, anything further today?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
Is there a PAC code?
I think. you did that.
Is it? Yeah.
Okay, thank you, Mr. Kylander. That's all.
Thank you, Mr. Kylander.
Are you Miss Ash? Okay, if you want to come forward to the podium, please. This is People versus Sue and Ash, case number 244888. The record should reflect that Miss Ash is present here in the courtroom today. I could have counsel put your appearances on.
Ryan, so we're gonna be at Your Honor.
Thomas Seeger, appearing with Mr. Ash.
This is set for a status conference today. Mr. Seeger, have there been any plea discussions in this case?
There have been, Your Honor. And Your Honor, if the court would indulge and give us an additional 30 or 60 days, I'm quite confident that we'll have it resolved. There were just some things that I was trying to discuss with Ms. Ash and maybe with the prosecuting attorney, to determine whether variation of the current offer would be possible.
Mr. Ziegler, do the people have any objection to that?
I don't have any objection to adjournment. Your Honor.
Okay. So, Mr. Seeger, the court will set this for a plea cutoff in 60 days. So Ms. Ash, what that means is between now and that next hearing, which is going to be in about 2 months, you need to stay in touch with Mr. Seeger, first of all. And then when we come back for that next hearing, I'll need you to have made a decision about whether you want to accept any plea agreements, okay?
Yes, sir.
And that will be the date for your final answer on that. So if you decide not to enter into a plea agreement, then we'll set it for trial and the court won't accept any plea agreements after that, okay?
Yes.
So that's a big day. It's important to make sure that you've made a decision by that point, okay?
Yes, sir.
Mr. Ziegler, anything else that we need to address today for the record?
No, Your Honor.
Mr. Seeger,
No, sir.
do you have any questions, Ms. Ash?
No, sir.
Thank you. That's all for today.
Thank you.
Your Honor, if, the 9:15 showed up.
Sir, are you Mr. Cross?
Yes, sir.
Okay, you have to go right to that podium there, please. And on the record, this is People versus Brian Cross, case number 234875. The record should reflect Mr. Cross is present here in the courtroom today.
Ryan Ziegler, Your Honor.
Thomas Seeger, appearing with and on behalf of Mr. Cross.
Okay, this is the date and time set for sentencing in this case. Mr. Cross, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes.
Okay. Mr. Seeger, are there any additions?
There are no material descriptions or deletions.
For the scoring of the guidelines.
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
And any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, this is a possession of meth case. The defendant has gotten the benefit of getting the habitual fourth offense notice dismissed. Mr. Cross does have some criminal history. His benefit was some time ago. The recommendation, I think, is appropriate given the history of this case, particularly his bond violations. I think that probation might have been more of a strong consideration for the court, if not for the fact that Mr. Cross has been violating his bond and has been consuming controlled substances, both alcohol and methamphetamine, while on bond. Given those facts, Your Honor, I think the recommendation for sentence of local incarceration is appropriate. I would ask the court to sentence this defendant somewhere in the middle of the guidelines.
Mr. Seeger?
Your Honor, by way of allocution, and to his credit, there has been a 10-year gap, and it's reflected in the pre-sentence report, or at least the writer had mentioned that there's been a 10-year gap in criminal history. Additionally, Your Honor, at least, I can't really endorse somebody using drugs or violating the conditions of the bond, but I do understand that it happens, and simply because there's an order that says you need to discontinue drugs when you've been using them for a period of time, it's probably not an easy thing for people to do. but it clearly is probably in his best interest and he's making the right choice when he does that. But at least he was honest. He was interviewed about his use. He didn't try and hide it. He didn't try and lie. He was honest with the probation officer. So I think that's also meaningful. To my understanding, he's trying to work. He's trying to support his family. He's trying to do a lot better with some of the things that he struggled. This is a drug case. There's no indication that he was selling it. That is also reflected in the pre-sentence reports, just a case of general use. Whereas in, it's clearly a meaningful felony. And clearly, he has a prior criminal history. It's probably not the crime of the century. He probably represents more of a danger to himself than the public. But even as a mayor, he does recognize what he did was wrongful. He accepts the consequences of it. It's just a question of what the court wishes to do. On one hand, if the court thinks that incarceration and no probation is appropriate, then he would accept that. To the extent that the court thought that probation was more amenable to him, and he would accept that as well. But if the court were to put him on probation, I would ask the court to consider holding any time time. To the extent that the court thinks that probation is not necessary, then I would ask the court give him a nominal sentence. Probably make it more difficult going forward. He had indicated that, albeit he does have work available to him, he's still somewhat struggling financially, and he's just trying to right his shit. To his credit, while he's been out, albeit he's not completely embraced his bond and followed the limits of it, he hasn't picked up any charge, so I guess that's also. So it's an unfortunate situation that he finds himself in. He recognizes what he did was wrong. For some grace to live in that jail.
All right, thank you. Anything you wanted to say today, sir?
No, sir.
Okay. I did read through the report, so I'm familiar with your circumstances and background. I'm familiar with the facts of this particular case. And yeah, I mean, you had a significant gap in convictions, which is a positive thing, certainly. And I think, outside of the bond violations, I probably would have been inclined to just go with fines and costs in this case, given the lack of severity of this particular offense and that gap in your conviction history. But your behavior on bond, it's a court order that you're supposed to follow. And I agree with Mr. Seeger completely that just because the court issues an order doesn't mean that all of a sudden you don't have a substance abuse issue and that you're just going to stop using. But what it does mean is that if you can't do it on your own, then you need to seek out some help for yourself. And I think you need to do that anyway, because I think clearly you're continuing to use in spite of court orders, in spite of negative consequences like arrests, and what that means is that it's out of your control and you need help to deal with it. The other thing I would say is your past convictions are, pardon me, going to catch up to you at some point. You've had 3 prior times on probation, 3 prior jail sentences. Your guidelines here are 0 to 17, which means that your next conviction is likely to result in prison guidelines. So you're running out of chances to get a hold of this. And so I hope that you do seek out treatment. I think because of the bond situation, penalty is appropriate in this case, and jail time at the low end of the guidelines to address your failure to comply or failure to get some kind of treatment to help with your compliance while you were on bond. The court is going to sentence you to 90 days in the Kalkaska County Jail. You do have credit for 1 day served. The court is going to order a crime victims assessment of $130, court costs of $325, a fine of $100, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of this sentence. We're going to provide you with some paperwork that we can figure those. These papers are going to explain to you, Mr. Cross, how to seek an appeal of this sentence, as well as how to request a court-appointed lawyer to help you with any appeal.
Your Honor, for the record, returning a copy of the appellate rights.
Mr. Cross, you have any?
Can I just see it?
Is Miss Hampton gonna be brought here? Do you have her in the holding room or are we gonna?
Yes. Yes, she is in the holding room as we speak. At least I hope she is.
I wasn't sure if she was in Wexford or somewhere else.
Yeah, no, she's here. Well, let me make sure I didn't tell you.
Possible to call Miss Hampton, if she's up.
Yeah, she is. That's what we're, can we bring her in?
Yes.
Your Honor, I'm not sure what the court wants to do, because I understand you're taking care of this for Judge Hunter, but to the extent that you want to enter a plea.
Sure. Okay. Have you been appointed to that file?
I haven't, Your Honor, but I did discuss with her, her financial situation yesterday, so I assume she'll fill out the application as I do. And then I'll just assign myself and then I'll take care of it, when it gets back on the docket. Unless you're doing sentencing today. So,
I'm willing to handle how, take it as far as we can. You okay?
No, I have no eyes.
Okay.
no, I don't know who that is. It's still, it's a problem because. I'm not- Okay, that's good.
So Ms. Wagner, I have to mute because this is a 7411 file, so I don't know if you want to have Agent Vera handle this or if you want to run over here.
Yes, I can come on over.
Okay, thanks. Versus Yoder, case number 244884. Yoder present here in court today, but we have counsel with appearance on this file.
Ryan Ziegler, on behalf of the Legal Honor.
Thomas. Yoder.
Thank you. This is set for a plea hearing today. Mr. Seeger, how did we want?
Your Honor, this is somewhat of a unique file, and it's probably not general practice in at least in this circuit. However, in speaking with the prosecuting attorney, we were going to ask the court to consider entertaining an order of remand to district court, primarily, Your Honor, because there was an open OWI down there. And to the extent that he was going to enter into a plea, it's my understanding that people would offer him 2 counts of OWI, which if he was going to be placed on probation, it's probably better suited to be handled in district court. Otherwise, there would be 1 sentence in circuit court, there would be 1 sentence in district court. And so my understanding is that the felony would be dismissed.
So, okay, so essentially 2 misdemeanors is what the plea would end up.
Correct, Your Honor. 2 separate files, but 2 misdemeanors, one of which is clearly still in district court. So if we remanded, Your Honor, it probably would be helpful. I don't know if they'll put him on probation or not. Or it's somewhat difficult for the Department of Corrections to supervise.
Mr. Ziegler, you have an objection to that?
Your Honor, I think given the particular circumstances of this case, I think it's appropriate. He would be on probation for 2 separate OWIs, and it just makes sense to have them both in front of 1 court, as opposed to 1 being supervised by MDOC and 1 by the district court.
Okay, I agree. So I'll just ask counsel to prepare a stipulated order for the rear.
I'll create it today.
What's that?
I'll create it today.
Okay, great, thank you. And then Mr. Seeger, were you covering that added on arraignments?
Again, Your Honor, I haven't talked to Mr. Amos, but if they bring him upstairs, I can tell him.
No, do we have him here?
Yes, he is. We can bring him right up.
Yeah, let's do that, and then Mr. Seeger will give you an opportunity to speak with them, and then we can take care of that now. It's 11:15.
That's pretty helpful.
We'll take a short recess. Mr. Amos, if you can stand up at the podium there so we can make sure your voice is picked up on the microphone. This is People versus David Amos, case number 234845. Record should reflect Mr. Amos is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
And Seeger appearing on behalf of Mr. Moore Amos as the arraignment attorney.
Okay, so Mr. Amos, you're in front of the court today. Based on a bench warrant, you were released. You were originally sentenced to 6 months by Judge Hunter. You were released from that sentence to attend treatment. And this alleges that you failed to successfully complete that treatment. Do you understand why you're before the court here today? All right, Mr. Seeger, did you have a chance to speak to Mr. Amos?
Yes, Your Honor.
How does he want to proceed?
I think he did admit that he did not successfully complete treatment.
Mr. Amos, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Amos, you understand that by admitting to failing to successfully complete treatment, that it could subject you to the original sentence that Judge Hunter sentenced you to?
Yeah.
And that you could face additional penalties for contempt?
Yeah.
For failing to abide by that order? With all of that in mind, is it your wish to admit that you did fail to complete treatment?
Yep.
All right. Mr. Seeger, Mr. Ziegler, do any of you, either of you have any objection to the court proceeding to resolution on this
No,
issue?
I have no objections, Your
No, Your
Mr.
Honor.
Ziegler? Okay, Mr. Ziegler, anything that you wanted to say on behalf of the people?
Your Honor, obviously the actions of this defendant are not appropriate. It's going to result in additional charges for him, for which I've not yet formulated, but I fully intend to charge him with a number of new crimes as a result of what he's done here. I think in the underlying matter, Your Honor, he still has a sentence to complete, which was 6 months handed down by Judge Hunter. He definitely needs to be remanded to complete that sentence. So he'll be sitting for that period of time at least. If the court feels that additional contempt sanctions or other penalties are warranted, I leave that to the court's discretion.
Thank you, Mr. Seeger.
Your Honor, I guess I would just ask the court to allow him to serve the balance of the jail that was originally imposed. It's unfortunate that he didn't successfully complete substance abuse treatment, but he didn't. So I don't want to say there, Your Honor. It's just unfortunate.
All right, Mr. Amos, anything that you wanted to say?
Nope.
All right, Mr. Amos or counsel, does anybody have the date that Mr. Amos was released from the jail for treatment? Mr. Amos, do you remember when you left the jail to go to Bear River?
216, I believe.
February 16th?
Yeah.
Okay. All right, so Mr. Amos, the court is not going to impose any additional penalties for contempt here. It sounds like you're going to be facing additional charges. And so I think that'll serve as an appropriate sanction for your conduct here. Under the original sentence from Judge Hunter, you were to be given day-for-day credit for your time in treatment if you successfully completed it. So since you did not do that, the court is going to remand you to the Kalkaska County Jail to serve your 6 months. At the time of sentencing on January 16th, you had 20 days of credit. The court will also allow for credit between the date of sentencing and February 16th. And so your sentence will begin as it stood back on February 16th, and you will not get credit for any of the time that you were in treatment. So again, 6 months in the Kalkaska County Jail with credit for 20 days served as of January 16th, plus credit for the days up until February 16th. And I don't believe there would be appellate rights since the court is simply imposing the original sentence that's already been imposed by the court. Mr. Ziegler, anything further on this case today?
There you are.
Mr. Seeger.
No, sir.
That's all for today, Mr. Amos.
I'll appear if there's a hearing, but I imagine you're gonna want to do stuff.
All right, People versus Carly, and that is case number 234873. Could have counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
Good morning, Stephen Hanel on behalf of Mr. Carly.
All right, this is a date and time set for sentencing in this case. Mr. Hanel, I got a message just a few minutes ago from my office indicating that your client is not gonna be able to make it today.
That's correct, Your Honor. I got a message, I was coming from Grand Rapids, I got a message when I was about a Big Rapids this morning that his car wouldn't start. That's all I know of the matter. I usually contact him at his work. He said, I think he lost his cell phone in the middle of this case and hasn't gotten a new one, so it's been the easiest to get a hold of, but you know, if he would have let me know, I would have given him a ride, but I had to be on the road very early this morning, so it wasn't something I could easily fix. You know, we asked the court for an adjournment, otherwise we understand the court wants to issue a bench warrant.
Mr. Ziegler, do the people take any position?
Yeah, I believe this is the defendant's first failure to appear in this matter. I don't have any reason to doubt what Mr. Hanel was telling you. I would just ask the court to issue a show cause so we can provide the court evidence that this is the reason for his non-appearance.
All right, I did have a chance, of course, to review the PSI. I do know that the recommendation is for a sentence of fines and costs. So, I mean, in my view, that doesn't provide a motivation for the defendant to intentionally or willfully avoid sentencing in this case. Further, he has had contact both with counsel and the court. So I will set this for a show cause and the court won't issue a bench warrant at this time.
Okay, thank you, Your Honor.
And the court will reset it for sentencing. But I will ask that you let Mr. Carly know, number one, he needs to bring some kind of documentation reflecting why he wasn't here at court today, and that if he doesn't appear for the next hearing, the court will issue a bench warrant.
Thank you, Your Honor. I don't want to drive up here without him next time anyways.
All right, thank you.
All right, thank you.
Our next hearing set for 10 o'clock. We'll take a short recess until then. Are we ready on Mr. Morrison's case?
Yes, sir. Mr. Morrison's in the courtroom, Your Honor.
People versus Morrison, case number 244887. If I could have counsel put your appearances on.
Brian Ziegler.
Kyle Travis on behalf of Mr. Morrison.
How did we want to proceed today, Mr. Travis?
Your Honor, in speaking with the prosecution and somewhat in, I think probably the prosecution would say directly tied to the resolutions of Mr. Morrison's other cases in other counties. It's my understanding that they would offer a misdemeanor, 1-year misdemeanor of a larceny between 200 and 1,000. Morrison had similar files in Antrim and Grand Traverse and Wexford. In Antrim, he pled to a attempt uttering and publishing a 5-year felony in his sentence coming up, and in Grand Traverse, he pled to a similar 1-year misdemeanor. In Wexford, he also pled to a similar 1-year misdemeanor. As part of that plea in Wexford that was just brought up is that he give truthful testimony. We have reached that offer, never had a full-blown discussion, but he would if requested.
All right, so this would be added count 4, Mr. Ziegler.
That is correct, Your Honor, of a larceny 200 to 1,000. It's a 1-year misdemeanor. I would also note that any and all restitution related to this file would be preserved as part of the plea agreement.
Yes,
You have a tab code for that added count.
Thank you, Your Honor. It's 750.3564A is an add.
Mr. Travis, was there something else that?
No, I just was agreeing with the prosecutor. We had discussed, obviously, restitution is part of this.
Okay. Mr. Morrison, have you had a chance to speak with Mr. Travis about this plea agreement?
Yes.
And is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Morrison, are you currently on any kind of probation or parole?
On probation for Wexford County.
Okay. Do you know if this plea is going to affect your probation or result in a violation there?
As far as I know, no, won't be a violation.
Okay. And then you understand that the maximum penalty that you could face here would be up to 1 year in jail in addition to fines. And with that maximum penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you at a trial. You have the right to have the court order any witnesses here at trial. Right, silent during a trial, not have that silence used against you. By the trial yourself if you want. And giving up and waiving all of those rights by pleading guilty today.
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything? You're in court today.
No.
Your own free choice to enter this plea. Are you pleading guilty because you are guilty?
Yes.
Mr. Travis, I'm not sure what the factual basis for the larceny. I don't know if there was actually a larceny or we're taking the factual basis to the other charges.
Your Honor, largely a factual basis to one of the other charges. I do believe that cash was received, which would also arguably be a larceny too.
Okay, I guess I'll just ask that you conduct some questioning of your client then to establish if that's what this is here.
So
Last year,
in November of 2022, the end of the month, roughly the 30th, were you in Kalkaska County?
Yes.
Were you given some checks to go cash at a local bank?
Yes.
And those checks were not valid checks, they were forgeries?
Correct.
Somebody else prepared those checks, not yourself?
Correct.
And you did take them to a bank here in Kalkaska County?
Yes.
And were you able to receive funds?
Yes.
And those were not your funds?
Correct.
And they weren't legitimately, you didn't have a legitimate reason to get them?
Correct.
Mr. Ziegler, are the people satisfied with that as a factual basis?
Satisfied either as to the uttering and publishing count or as to the larceny count, Your Honor.
Thank you. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Morrison, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Agent Vera here before you leave the court to set up a pre-sentence interview. And then we'll set this for a sentencing hearing. Just make sure that you stay in touch with your attorney, Mr. Travis, prior to that hearing. And that's all for today. Thank you.
Thank you.
People versus Trepanier, case number 244891. Yeah, counsel, put your appearances on in this file.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Trapaner.
Mr. Travis, how did we want to proceed in this file today?
Your Honor, we would ask the court to give us 30 days. There were some issues that came up at the prelims that were issues, but then the whole potential of them, I didn't realize till thinking about the matter later. I spoke with Mr. Ziegler about that. He did not conduct that prelim, so I have a transcript ordered, but we definitely like to talk about that before we really do anything else.
Your Honor, I would agree. It was brought to my attention that there may be some technical legal issues based on the testimony at the preliminary exam. Mr. Travis and I would like an opportunity to look over that transcript before proceeding.
Have you already ordered that?
It has been ordered, but it was just on Mr. Ziegler, a little hiccup in communication. It probably just officially became ordered at the end of last week. I had included it with another email and another communication, and thought afterwards that I should follow up and check and ask, and it was confirmed, yes, that it got missed when I attached it in another response. So it is ordered. It has been in the queue, but just basically last Friday is when it got truly in the queue.
Your Honor, after being notified of this by Mr. Travis, I went back and checked my file. It looks like we also ordered a copy that was back on February 23rd.
Okay. All right, I think unless either of you have an objection, I would set this for status conference at about 60 days out. That'll give both of you an adequate opportunity to get the transcript, go through it and discuss it. I'd rather do that than rush back in 30 days and not be ready. Do either of you have any objections to that?
No, Your Honor.
No, Your Honor.
Oh, thank you. Okay, so the court will send out that notice of that hearing. Mr. Trepanier, just make sure that you stay in touch with Mr. Travis so that you're ready to proceed when we're back here in about 2 months. Okay. All right. Thank you.
Thank you, Your Honor.
Curtis.
Is Ms. Matson lodged?
Yes, she is in holding. She'll be here momentarily.
Ms. Matson, I'm going to have you go right to the podium there, please. You're on the record in People versus Jessica Matson, case number 234880. The record should reflect Ms. Matson present here in the courtroom today. Counsel, put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Matson.
This is the date and time set for a sentencing hearing in this matter. Ms. Matson, have you had a chance to go through the pre-sentence report and talk to Mr. Travis about that?
I have.
Travis, are there any additions to
Your Honor, I guess one that we'll just mention, I know usually the court doesn't change things in the description of the offense of the police report, but she would note it indicates on page 2, second paragraph, last line. She stated that her ex-boyfriend, Brian Minshaw, Brian Minshaw is her cousin, not an ex-boyfriend.
Any objection to that change? Court will order that the report be presented to you.
Oh, and Your Honor, currently the name is spelled. That's the initial name.
Michelin like the tire. Any other corrections? Any challenges to the scoring of the guidelines as to either?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I think that given the circumstances of this case, and more importantly, things that have happened regarding Ms. Matson after this case and after the plea agreement was reached, particularly these incidences in the jail for which she's facing very serious charges in other counties, the sentence is unlikely to control her future. However, given the fact that she's controlled substances, given the fact that she's committing crimes in jail following this case, I don't think she recommends herself well to a probationary sentence. I don't think she recommends herself well to a sentence at the lower end of the guidelines. I would just ask the court to give her 11 months and to make her Sheboygan County's problem going forward. Thank you.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, obviously, Ms. Matson has struggled greatly in the recent years to deal with her narcotics problem. She does have children who are with their father. That is still a great motivation to her and a great desire. Her and I have discussed, and she knows clearly she's struggled when getting out lately with her narcotics problem or methamphetamine problem. She knows she needs rehab. She knows she needs treatment. Likely in Sheboygan, more serious. What she's talking about, she's hopeful to get some sort of boot camp sentence. That's not been, the plea hasn't even happened, and obviously that there's a lot of steps before they would happen. She's also a member of the Sault Ste. Marie tribe and has opportunities for expanded opportunities for rehab. She is considering, depending on what happens here and what goes forward, she wants to get treatment. However, she can, but likely she is facing some pretty serious sanctions over in Sheboygan. And she's also, as indicated in the report, has problems back in Grand Traverse. That too may all be eaten up by what happens in Sheboygan. So all that she is, as the prosecutor indicates, going to have pretty substantial problems after this. I would ask the court to give her a sentence somewhere in the middle of the guidelines. Not that necessarily it would be reasonable, and she's definitely not a good probation candidate from this court's perspective, particularly with a more serious case pending, but that she may, if she were to have a boot camp opportunity, have that prevented if she has too long of a sentence here. So that's why I'd ask the court to consider maybe something less than the 11 months. So if she is potentially given a chance to do some sort of program like that, that she wouldn't be prevented from doing that by this sentence. Thank you, Your Honor.
Thank you, Ms. Matson. Anything that you wanted to say today?
I'm just sorry for wasting your time, and like he said, I know that I've caused more problems, but I understand that I need long-term, and I need to get home. My children deserve a sober mother, and I've never been given that chance. And that's all.
Right, thank you. I did read through the report. I'm familiar with what happened in this particular case. Through the information in the report, I'm also familiar with your other matters that you have pending, and your background information through the report that was prepared by Grand Traverse County. So the court has a good overview of where you're at, how you got here, and what's likely to occur based on your ongoing matters as well. Looking at things as a whole, I mean, you're right, I think you need some long-term treatment. And I think to the extent that you have extra resources through your affiliation with the tribe, that you should take advantage of anything that you have available to you to help you with this. You've gotten yourself into a bad spot here. I think given the nature of your conduct, both in this case and in the related cases, there's not a lot of mitigating factors or reasons for the court to go with a lower sentence here. I don't think a sentence in this case is gonna affect your ability to participate in the boot camp program if that's what ends up happening in a different jurisdiction. And I think ultimately that might be good for you. That's gonna give you some more opportunities again for treatment. But as it relates to this file and the charge here, and I also agree that I don't think probation at this point is appropriate. I don't think that would be beneficial to you or to the community in general. So based on what occurred here, I think the sentence within the guidelines, but at the top end is appropriate to account both for your conduct here and your past history. So as to each count, the court is going to sentence you to 11 months in the Kalkaska County Jail. You do have credit for 33 days served. As to count 3, the court is going to order a crime victims assessment of $130, cost of $325, attorney fees of $350, and $136 state cost. That's $68 for count 2, and $68 for 3. Those 2 sentences to be served concurrently to each other. You do have the ability to seek an appeal of this sentence, and Mr. Travis, if you can provide. Mr. Travis says, Ms. Matson.
She has, Your Honor.
And you are remanded to the custody of the county at this time. Next hearing is set for 10:30. I see that's office, so I don't see them after that. All right, Mr. Pappen, are you able to hear me okay?
Yes, Your Honor. Thank you.
Okay, just 1 second. Okay, Mr. Ross, I just needed to unmute. Are you able to hear me okay?
Yes, I can hear you.
All right, very good. Thank you. We're on the record now in People versus Aaron Ross, case number 244882. We have Mr. Pappen present by Zoom video on behalf of the state. Mr. Ross is appearing today by Zoom, and his attorney, Mr. Travis, is present here in the courtroom. This is set for a status conference in this case today. Mr. Travis, on behalf of Mr. Ross, can you tell me where things are at from your side?
Thank you, Your Honor. Your Honor, Mr. Ross, last month, posted a substantial bond. Was allowed by the court, the Attorney General's office, to return home to Montana. He's really just kind of gotten back and settling in, working on restarting employment. There is a number of fairly complicated issues surrounding this case. They may not necessarily really be directed to the case, but they're involving Mr. Ross's son, and questions now that he's back in Montana about what was happening to funds that he was paying for child support, that maybe that they were being taken by the state of Montana for other cases. But Mr. Ross has got some things he wants to look into. So we would ask the court if we could have a 30-day adjournment of this matter. I think largely we're going to eventually resolve it with a plea. But I think Mr. Ross wants to check into some of his own issues, which may have an effect on this case, but I don't know if they will. But he's got some real questions about what was happening with the funds in Montana and where they were going, which I can't really help him with. But now that he's back in Montana, he can investigate that a little more. But largely, I think we're on track for a resolution, but he just has some questions basically he wants to talk with me about and potentially talk to somebody in Montana about.
Okay, Mr. Pappen, the defendant's asking for a 30-day adjournment. Do you take any position on that?
I won't object, Your Honor.
Okay, Mr. Ross, is that how you'd like to proceed as well?
Yes, sir.
Okay, so I think it's reasonable to give you an opportunity to look into those matters and see how, if at all, that may affect a resolution of this case. So the court will set this for a status conference in about 30 days. At that point, though, Mr. Ross and Mr. Travis, I think we'll need to make some progress on resolving this one way or the other, whether that's through a plea or setting it for trial.
Thank you.
Mr. Pappen, anything further we need to address on behalf of the state today?
No, thank you, Your Honor.
Mr. Travis?
Nothing further, Your Honor. Thank you.
Mr. Ross, do you have any questions at all?
Not at this time.
Okay, just make sure that you stay in touch with Mr. Travis so that you're prepared to go forward at that next hearing, okay?
Yes, sir. Thank you.
Okay, thank you. That's all for this case, and you're both free to disconnect at this time.
Thank you.
All right. I will be in touch. Thank you.
Thank you.
Okay, the next hearing is at 10:45. That's also going to be with the defendant by Zoom, so we'll take a recess. right, Mr. Fields, are you able to hear me okay?
Yes, sir, Your Honor.
All right, thank you. We'll go on the record now. This is People versus Fields, case number 234870. The record should reflect Mr. Fields is appearing for this hearing today from Ingham County Jail by prior arrangement. We have Mr. Horowitz here in the courtroom on his behalf and Mr. Ziegler on behalf of the people. Mr. Fields, this is the date and time set for a sentencing hearing in this case. You had an adequate opportunity to go through the pre-sentence report and talk to Mr. Horowitz about that?
Yes, sir.
All right, thank you. Mr. Horowitz, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, I would just note, although it's not reflected anywhere in the pre-sentence investigative report, that the plea was made with an understanding that the defendant would have HIDA, or at least there was an agreement to recognize HIDA. And so I would ask that that be reflected in the PSI. That was part of the agreement.
All right, any objection to that, Mr. Horowitz?
No, Your Honor, that's an accurate statement of the agreement.
Okay.
Your Honor, one minor correction to the face sheet, the sentence date says 2/6/24. I'd ask that be updated to say 4/2/24.
Yes, okay, thank you. Okay, and do the people have any challenges to the scoring of the guidelines?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I believe this is the last defendant involved in this Green Farm break-in. I can't recall if the court's had prior defendants, but I'm sure the court is familiar with the facts involved in this matter. This particular defendant was the driver, so we got some additional charges. His juvenile record is quite extensive, Your Honor. I don't know if I've ever seen someone with this many PRV points, despite being here on his first adult conviction. So certainly that is concerning. I continue to believe that HIDA in some fashion is appropriate, Your Honor. I don't know if this defendant is likely to reform or likely to take advantage of the benefits of HIDA. But given that this is his first adult conviction, I do think it is appropriate to give him the benefit of HIDA. The recommendation is for 1 year incarceration in the county jail. I also think that is an appropriate recommendation, Your Honor. They're not mutually exclusive. The court is certainly free to impose a jail or prison sanction as part of a HIDA sentence. So I would ask the court to consider giving this individual a HIDA sentence with some incarceration up front and give him an opportunity to reform. I also completely understand if the court looks at its prior record and its pending charges and decides that HIDA is not appropriate, at which case I would just ask the court to follow the recommendation. Give him jail of 12 months. It is his first adult conviction. I think that's an appropriate sentence.
And just to clarify that the plea agreement was for the prosecution to recommend HIDA, not for that as part of the sentence.
Your Honor,
in other words, there wasn't a Killebrew agreement for HIDA. Or is there?
I don't recall if there was a Killebrew agreement, Your Honor. My notes reflected we were going to enter a plea to counts 2 and 3 and that we would recommend HIDA sentence.
Okay, thank you. Mr. Horowitz. Anything on behalf of Mr. Fields?
Maybe there's we might have to go back and look how we stated it. The plea agreement as I see it is that Mr. Fields could plead to counts 2 and 4 initially under HIDA, and then we revised the counts. So I think that HIDA was an understood component of the plea agreement. But of course, the court can always not agree to be bound by that. Just in which case we might have to go back to the drawing board. There might be an academic distinction anyway. That doesn't matter.
All right, 1 second. Mr. Fields, did you have a question?
I was under the recommendations that I was gonna get higher probation. I already been locked up currently 9 months. I've been had the hold on me since I've been in here. And I'm just ready to change my life. I know I fucked up. I did some fucked
Mr.
up shit.
Fields, it's not the time for that, Mr. Fields. You'll get a chance to make statements if you want, but it's not now.
Okay.
If you have questions, let us know.
All right,
Okay.
so I don't, after reviewing the pre-sentence report and Mr. Fields' juvenile record, I mean, my view is that HIDA is for young individuals who make, you know, a one-time mistake based on youth and inexperience and bad judgment. Mr. Fields' juvenile record does not indicate that to me at all. Mr. Fields has continued to violate. So in my view, HIDA, the purposes of HIDA aren't present in this case, and I don't intend to impose that. So I think we do need to determine whether that is part of the plea agreement, because if that's true, then Mr. Fields would have the ability to withdraw his plea here today. If it wasn't part of the plea agreement, then the courts would proceed with sentencing. So Mr. Fields, are you telling me that your understanding of the plea agreement was that you would receive HIDA?
Yeah, I had probation.
And he's
Your Honor.
clarified that step of the way, and
Yeah.
also every chance he's got has said that.
So Mr. Fields, as I indicated, I don't believe HIDA is appropriate in this case, and it would not be my intent to sentence you under HIDA and give you HIDA probation. So that would allow you the option of withdrawing your plea here, or proceeding with sentencing with the understanding that the court would not give you HIDA probation. So those are your two choices here today. If you want to have a chance to speak with your attorney more about your options, do you know what you want to do?
Judge, I would ask for the time. He's being held on other cases regardless.
Yeah.
He'll be continued to be held in this case. Understanding we'd all like to move the docket along. I don't think that, I don't want to put him on the spot in that way. I appreciate your honor, making that announcement, and giving us the chance to at least discuss it. A short adjournment would probably be helpful, so that I could speak to him at over the phone.
All right, Mr. Fields, do you have any objection to taking some time so that you can speak with your attorney?
Yes, sir. I just don't, like, what's going on? This is my first adult case, and I never, like.
Mr. Fields, the court has said that the court is not going to impose a HIDA sentence, does not think that HIDA is appropriate. So the court is going to give us a chance to discuss your case and figure out our next steps.
I thought my plea was already accepted.
Can you say that again?
He thought his plea had already been accepted.
Yeah, your plea was accepted, but Mr. Fields, as the judge, I have the option of determining whether or not I think HIDA is appropriate. And you've got 13 juvenile convictions, and based on that, I don't think HIDA is appropriate. So that's the court's decision, and you're going to have to work within that going forward.
And the questions that you have right now, you can discuss with me, but we should not do it over Zoom.
Okay, sir.
Okay, so the court's going to adjourn this hearing for today's purposes. The court will reset this for a status conference at its next available date, so we'll get it on the docket as quick as we can. In the meantime, Mr. Fields, you're going to have a chance to speak with Mr. Horowitz privately so that you guys can have a candid conversation about what your options are going forward.
Mr. Fields, I know that you called yesterday and I wasn't able to take it. I'll be around this afternoon if you want to call.
So what do you think that's appropriate? What's appropriate for me, sir?
That's what you're going to talk to him about on the phone. So you'll have an opportunity to get some advice from your attorney about how to go forward. And that's going to conclude our hearing for today.
Thank you, Your Honor.
We have Mr. Glaro. You ready for him?
Yes.
Okay.
so we'll go on the record in People versus Glaro. Glaro, you go right to the podium there, please. Thank you. We've got a number of different files up for hearing today. File number 214552, 224645, and 24885. I can't count it with your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
That's the case with Big Ben.
The new one for that was for later and it got moved on. I guess council, I mean, you guys talked about how we want to pursue the cases today.
Judge, if there's any other questions, then I think that's gonna be my team today. Mr. Glaro has a new open district court felony that hasn't yet made it to the circuit court, scheduled for prelim, I believe, on the 8th. The people have extended a global resolution to resolve all the cases. I mailed that to Mr. Glaro last week, but he hasn't received it yet. We talked about it briefly today at the jail, but it's complicated. So he's not in a position to make a decision on all the cases yet today. And it's kind of an exploding offer that requires that we figure something out by the prelim.
Okay, so is it something that would resolve all the files? Is that
Correct.
kind of what you guys want to do, is just get everything all together?
Yes.
And then figure out a resolution?
Correct.
All right, Mr. Glaro, have you talked to Mr. Horowitz about how we're going to go forward?
Briefly, spoke with him prior to this hearing right now, over at the sheriff's office.
You okay with that request?
Yes.
Okay.
Okay, you don't have any objection to that?
No, sir.
Council, when would either of you suggest the court set these files for hearing?
I'd say at least a month. The prelim and the next case scheduled for the 8th. So if there's a bind over on that date, it won't be until, I mean, it won't be arraigned, well, it will be arraigned on the 8th. That's how we do it here. Say at least a month, Your Honor.
Mr. Ziegler?
I would agree, Your Honor. Assuming the bind over happens and it gets assigned to Your Honor, we could possibly have it done in a month. But I don't know if Mr. Glaro might need some more time to consider whether he wants to accept the offer and bind over.
Okay, I am going to direct that file, if it's found over, be assigned to me. And the court will set this for all 4 cases once that one's found over for a status conference. I'll make it at least 30 days so that the parties have an opportunity to communicate regarding offers and that Mr. Glaro has an adequate opportunity to consider those offers.
Thank you, Judge.
All right, Ms. Wagner, did you have something that you needed to add?
I do, Your Honor. A technical show cause was issued and signed by you on March 18th to be set for today. So that show cause had already been issued, but then he ended up getting a bench warrant for another matter for new criminal. So I think we just need to do the arraignment on that show cause, which might be a moot point because he's already sitting in on, I think, 3 different bonds that he hasn't posted.
Yeah, so I'm just gonna move that show cause hearing out to the next status conference.
Okay.
And then we'll see where we're at that point.
Okay.
But thanks for addressing that.
Thank you.
Okay, Mr. Glaro, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today.
Thank you.
And then one final file for the morning, People versus Jeremy Knoll, file number 234798. I did communicate with Agent Bear up this morning. He indicated that Mr. Knoll is currently lodged in Grand Traverse. And his indication was that we would just have this reset. I think that's where you were going with it too, Mr.
Yeah, that's no objection to that. He is in custody on a new sentence in Grand Traverse, as well as the imposition of time it was held in abeyance. We don't object to pushing it out.
Okay, so the court will move that out 30 days. Any objection to that? Okay. Okay, thank you. Our morning docket, the court will be in recess.